CLS Talks.
Talk to me. Talk to me. Talk to me. Talk to me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that want it. They don't talk to me. They back. That want it. They don't talk to me. They back. That want it. They don't talk to me. They back. That want it. They don't talk to me. They back.
Welcome back to the CLS Talks. Des Carthy joins me. Lionel Coveney. How you doing, Des?
I'm great, Lionel. Thanks very much. How are you?
I'm good. Someone who wasn't good at this point when we last left him was our man Tom, who was on his way to court after a night in prison. Let's delve straight into it. What's going on with Tom now? He's had an hour's sleep and he's back at the court.
So Tom has now left Mountjoy prison with the two guards in the van.
Clover Hill, wasn't it?
Sorry,
yeah.
Clover Hill.
It's all prison anyway.
It's all prisons anyway. So then he left Clover Hill, and just to go back over something that happened, and it was chapter 7 in the book is called No Bail, Just Jail. And Tom used that title for that chapter because in the holding cell where he's held in Clover Hill prison, there was actually scratched onto the wall, somebody had scratched onto the wall, No Bail, Just Jail.
Right.
So he thought that's an appropriate title to have for a chapter.
So this has been done before.
So that's fine. So Tom then finds himself in Portlaoise Courthouse, and the accompanying guard, now from memory I think the accompanying guard, his name was Dave. Tom started speaking to Dave, the accompanying guard the Síochána, and he seemed like a reasonable sort of fellow, and Dave asked Tom at one point, like, what have you done, why are you here? And Tom genuinely had to say to Dave, I don't know. So the guard then said, well, you probably won't be here for long, it was only a minor thing. And Tom said, no, you watch this, you'll be here all day and I'll be here all day, they will not hear this case until the afternoon. And Dave the guard said, no, I don't think so. If it's something simple, they'll hear it straight away. And Tom says, no, they won't.
Well, it already hasn't been simple for the last 2 days.
So then Tom and Dave were sitting down having the chat, as you do with the Garda Síochána
all the time.
And then Garda Mahoney approaches Tom and the Garda that was sitting with him and throws some documents at him and said, you're served with more charges.
In the court?
No, this is on the bench outside the court. There's a bench, a row of benches out there apparently.
Right.
So whilst he was in the custody of a Garda Síochána, the other guard, Garda Mahoney, who was the charging guard, tried to serve Tom with more charges.
Is that considered successful service?
Well, that's a good question. I don't think Tom ever got into that, but in retrospect he accepted the charges in the aftermath. But at that point in time, the guard that was with Tom said, come on, let's go. And the documents, whatever they were, i.e. the service of more charges, were left on the desk.
Okay.
Yeah. So Tom didn't put his hand on them, and the guard that was with Tom realised, well, this probably isn't right, so they both left together.
Right.
So in that context, Dave probably helped Tom and said, well, let's get out of here, we'll go into the court and sit down. So that way, nothing else happens. So then Garda Mahoney was left with his knob in his hand, so to speak. Excuse the expression.
I'd say he's well used to that.
Yeah. So then they were in court, and from what Tom tells us anyway, there was a lot of guards there, and initially when it was called in the morning, it was rolled over into the afternoon. So of course there was lunch to be had and all the rest of it. So they came back in the afternoon, and then Dave the guard realised, maybe this guy is right, this won't be heard. So after the end of all the cases, then they called Tom's case, and the first gesture that Judge Catherine Staines had for Tom was, do you want to go back to jail again? That was our opening sort of take on the proceedings. And Tom said, well, nobody wants to go to jail.
Yeah.
Or who wants to go to jail? Some words to that effect anyway. And Judge Staines said, well, are you prepared to sign this bail order? And Tom...
So, I am of the understanding, correct me if I'm wrong, Des, but this is a little bit frustrating. As I understand it, you can't be forced. There's no law that obliges you to sign anything.
That's correct, yes.
Yet they're threatening to send this man to jail if he doesn't sign something that they want him to sign.
Correct, yes.
Okay, I have a problem with that.
Well, like everybody should have a problem with that, and Tom had a problem with that. So it was put to him again by Judge Catherine Staines that he should be signing this thing if he wanted to walk free and not go to jail. So Tom said, well, at least let me have a look at it, because at that point in time Tom didn't even know what this bail order was. And again, you have to think about this, he didn't know what the charges were. He hadn't been properly charged with anything, and yet apparently there was more charges coming, which he knew about. So eventually Judge Staines said, well, I'll show you the document, and Tom read the document, and Tom said, well, I don't understand any of this. And Judge Staines says, well, you'll have to sign it if you want to go. And he says, well, I'll sign it, but I'll put a caveat on it that I don't understand it. And Judge Catherine Staines said, well, you put what you want on it, but sign it.
Okay.
So he wrote down words to the effect, I think there's a copy of it in the book anyway, that he did not understand what the document was. So it inferred then that he was signing it under duress.
Okay.
So that's an out. And Tom realised then, well, at least I've signed it, I know I can go free, and I can always take it back because it was signed under duress, which is clear by the fact that I do not understand what the document was. And he started writing on the document to state clearly he didn't understand what the document was, what it meant. And the guards approached him then while he was writing this down to put more pressure on him to sign it. So he was surrounded by guards.
This is
the
truly
public weren't
incredible.
in the court at this point.
Yeah, and I suppose we're meant to believe that was an accident too.
No, it wasn't an accident. The very last case, the court was filled, not to the brim obviously, but there was guards all around.
The Gardaí all stayed, even though they wouldn't have had their own cases to deal with or anything.
They probably found it very interesting.
Yeah, unbelievable.
And if they needed to manhandle Tom again,
ready to do it,
plenty of force to do it.
Yeah.
So the pressure was put on him to sign it, and then he did sign it, and then he said to the judge more or less the effect, well, subject to this as well, I want a Gary Doyle order.
Okay.
So as we know, the title of the book is the Gary Doyle Order. So this is where the Gary Doyle Order comes in. Tom now had the chance, with that hour of sleep, he had the chance to think critically and thought, well, what can I do? So the Gary Doyle Order means that they have to produce the evidence.
Yeah.
So he insisted with the judge, and she said, yeah, I'll grant you a Gary Doyle Order. And then with that, he signed the document and he was let go.
What if she had said no?
She can't say no.
But they do sometimes, don't they?
Yeah, but they do sometimes, because if they suspect the man or woman in front of them don't know what that means, then they might challenge you on it, and we have had that before.
So it's to try and put you off it nearly.
Yeah, absolutely.
Okay.
Yeah. But it boils down to this. If it's a criminal charge, in this case they were criminal charges, and you can only find that out when you look at the legislation. It'll tell you potentially could go to prison over something like this.
Yeah.
It is demonstrably then a criminal charge, so you're entitled to a DPP disclosure under the DPP guidelines 2010, which is the Gary Doyle Order. The Gary Doyle Order, again, people probably know this, but if they read the book they'll find out a bit more detail. The Gary Doyle Order stems from another case, a High Court, Supreme Court case, whereby the defendant was seeking disclosure of evidence and the DPP didn't want to give it to, and eventually the judge had to say, well, look, I'll grant you an order for full disclosure. And they coined the name, the Gary Doyle Order, from the name of the defendant, who was Gary Doyle.
Yeah. So it's the same thing then as a disclosure order, yeah?
Completely, yeah.
Okay.
Absolutely.
Right.
And again, for people to cross-reference this, if they go to the DPP guidelines for prosecutors 2010, it tells you all about the Gary Doyle Order in there and what to seek in terms of disclosure and what you're entitled to and what they can do. It's like we gave the scenario before of playing a game of poker.
Yeah.
You can see their hand. They don't necessarily see your hand unless you give it away.
Yeah.
But you can see exactly what it is they have in their hand to use against you.
So why wouldn't you want to see it?
Everything, as far as I'm concerned, and probably yourself, Lionel, whenever you go to court, obviously look up the legislation in relation to what the charges are and potentially what could happen to you, be it a heavy fine or imprisonment sentence, whatever. Even for something as mundane, perceivably, as a TV licence, you should seek a Gary Doyle Order. It doesn't matter what it is, Gary Doyle Order all the way.
Well, then you know what you're up against.
Exactly. You will know what evidence they are purporting to have, and then you will be able to defend yourself against that or attack them based upon what they have. So it's very simple. Now again, as you suggested, the judges will sometimes feign ignorance about what a Gary Doyle Order is, and they'll challenge you as to what a Gary Doyle Order is, but all it is disclosure of the evidence.
Okay.
That's it.
Which you are entitled to.
Absolutely.
Grant, so he's been granted the Gary Doyle Order, and is it off with him then at that point? Home?
Yeah, then he mentioned the issue of the property that was held, i.e. the keys and the phone, and the judge says, well, you can go and get them yourself.
Right.
So he had to
So
actually...
he had to go back to the prison to get them.
Yeah. And he had to
wow.
wait then obviously for the whole process to get into the first part, then the second part of the prison,
Yeah.
and eventually then get his property. So it took half the day the next day to get the property back.
Yeah.
So
I mean, talk about making things difficult.
oh, absolutely.
And deliberately so.
Yeah. So then, again, we'll have to look specifically at the dates involved, but there was a couple of months would pass. The Gary Doyle Order, according to the judge, was supposed to be issued on X date, and then they'd have more time then to deal with the Gary Doyle Order, the disclosure and all the rest of it. So we'll get into that once we get into the next part of the proceedings, which was the next date, and we'll go from there.
Okay, so there's another court date. We're up to the 1st of November 2012 at this point. And what was this next court date for? This was just to establish a hearing date then, is it?
Yeah, so this 1st November date was 1 week later from when the man had been released under the bail order. And the bail order is basically him saying that he will come back to court, is agreeing that he will come back to court, which he has found out. So at that point in time, he went in on the 1st November, and this, as you suggest, was a date in which they would fix a date for the trial. So having said that then, given that he had been given the evidence and he then accepted further charges, the further 7 charges, was 1 charge started with and there was another 7 brought in by the guards.
Good grief, they're really having a go at him here.
So, they're going to get him. They're going to get him, right?
Yeah.
I hate to give away the ending.
At least they don't still have his keys though.
Exactly. So that was fine, and the court date set then for the next hearing, or the trial I should say, was the 22nd of March. Now Tom had to go to the trouble of reminding the judge that a Gary Doyle order was issued, that she had issued it, because she all feigned that she hadn't any knowledge of it.
And that was a week earlier?
Yeah. So Tom had to turn around and say to her, you better check your notes there, because I have a record of you saying that I requested a Gary Doyle order and you issued a Gary Doyle order. And eventually she said, yeah, she capitulated and said, yeah, well, the Garda Síochána have up to the 1st of January to release the information in relation to the disclosure.
He really is up against it then.
Oh, absolutely.
Yeah.
It's shocking. So, look, we have the dates set. We have the trial date of the 22nd of March, and we have the date of the 1st of January as being the date for the full release of the alleged, if you like, evidence of the guards.
Okay, so at this point we know, or Tom knows anyway, what exactly he's being charged with. Because he's seen the charges.
I think it's worth running through the charges for the listeners.
Yeah, I agree.
And obviously this is where we'd like some feedback as well. If people want to give us feedback on these charges, Tom in the book has given a breakdown of what the charges are in a sort of a more common explanation. We assist him with that and all the rest of it. But what we'll do is I'll read out the charges, and we'll try and give a sort of summary of what the charges are, so you can see how they're building up. Okay. So the charge sheet list starts on page 80 of the book, but the first charge here, which was the original. Now this is what the listeners have to keep in context. There is a grounding charge, the original charge, and everything else is built upon that.
So they must stem from this original charge?
Correct. Everything starts with the original charge. So if the original charge isn't right, the whole case falls.
Okay, so if you're looking to defend yourself, you defend this one first and foremost, and then you don't have to consider the rest.
Well, they will have you think that all the others are separate charges, and the judge will actually tell you that they're all other charges as well. But strictly speaking, if the first charge falls, everything falls. Okay. So the first charge there is what we've called the original alleged charge, an alleged offence pursuant to Section 63 of the Road Traffic Act. Now, I won't get into the technicalities; they're all there. But basically, in summary, it means where a driving licence or learner permit has been seized from a person. That's what it states in the Act. So the first charge was that they had seized a licence or a learner permit from a person that probably shouldn't have had it.
Okay, I'm a little bit confused by that.
Well, Tom was very confused by that.
Yeah.
That's the grounding charge they have.
So what are they attempting to say there, really?
Well, what it suggests here is that they took or
Did he have a false license or something?
yeah, they had a false license. They had to take this learner's permit or license, which was a fraud or wrong or not the right thing to have, and they seized it from Tom.
That's interesting.
Right, that was their grounding charge.
Okay, it's potentially pretty serious by the sounds of it.
Yeah. Okay.
Right.
Would you have to take into consideration? Right.
Yeah. Whether it's true or not.
Yeah. So this was the guards' grounding charge. Notwithstanding, they had 7 other charges. Now, you've got to wonder why at this point did they bring in 7 other charges.
Yeah.
Well, I suspect was because they had no case, so they had to build something in
Yeah.
to make it look like they had a case and confuse the whole issue.
Exactly. And if you weren't knowledgeable on the fact that the grounding charge is where everything stems from, you'd just see all these isolated, okay, well, the first one doesn't apply to me, but I still have to defend this other 7.
That's what the court would have you to believe.
Yeah.
Now, again, it's a nonsense, and I think we talked about this before, perhaps in other episodes. Now, you see, this is where we've suggested that when somebody's bringing a charge against you, you look at the specific legislation and all of the amendments that pertain to it, all of the amendments.
Yeah.
Okay. So there's all the stuff that should have happened before this charge was ever brought upon Tom. A sequence of operations that it's called due process.
Yeah.
That should have happened before any of these charges, not alone the original charge, but all the other charges, and no due process was followed. And seldom, if ever, when guards are charging people with charges, specifically road traffic offences, do they ever follow due process.
Okay.
Ever. So 99.99999% of cases under the Road Traffic Act can be beaten.
Based on them
Yeah.
not doing what they should be doing according to the process that is put in place for them on the side of the road.
Yeah, and it wouldn't have been the first time ever on this island that the guards were accused of not following due process and lost cases off the foot of it. So all I'm saying to people out there is that practically all charges that guards bring in their ignorance, and I'm talking about ignorance of the law,
Yeah.
they cannot be brought to court on. So you can win these cases.
Yeah.
So if everybody applied the logic that's contained within the book and the logic contained within the process of law itself, all road traffic acts, practically all I should say, can be beaten.
Right.
Okay?
That's very interesting.
It's, well, like, I mean,
Potentially seismic if people are willing to
absolutely
grow up
seismic.
here.
But you see, it also lends its way to the other thing we've spoken about before, is the ignorance of the law that the guards have.
Yeah.
They don't look at it. I'm not saying all of them are ignorant of the law, but I'd say the vast majority, according to our experiences and the people we've talked to, the guards just don't have the knowledge of law they should have.
Yeah. Well, I mean, these are the lads and ladies who were thrown out of Templemore after a few months, believing they have a law degree. That's the name that's put on whatever ridiculous piece of paper they're given.
Okay, so the next charge, now again, we'll summarise this because the detail is there for the readers to have a look at or listen to, whatever. The next charge is charge sheet number whatever, and then in summary it says, a person shall not drive a mechanically propelled vehicle in a public place unless he holds a licence from the time being having effect and licensing him to drive the vehicle. So it's all about a licence, basically.
Yeah.
So 1 minute they're saying that they've taken a licence, next of all they're suggesting there is no licence.
Yeah.
So that in itself is a huge contradiction.
Yeah.
So those two charges cannot stand together.
Well, you can't take a licence if it doesn't exist.
Exactly. Yeah, so that's fine. Now the next one would be 3, obligation to be insured or guaranteed. So we're talking about insurance, basically private insurance.
Yeah.
Now the man was insured and he could have proven that on the day,
Right.
but they weren't prepared. So the stupidity here is that they didn't even go so far as to investigate what the man was talking about in terms of the paperwork that he had.
Yeah.
They could have proven to the guards that he was lawfully insured to drive the private property he was in.
But they throw in the charge anyway.
And they threw in the charge anyway.
Wow.
That's ignorance now. You see, there's more to it than that. It's malicious.
Yeah.
It's malicious. They thought, right, we'll get him on one. If we don't get him on one thing, there's 7 other things we can get him on.
Yeah, so throw as much mud in there as we can.
And all of these things potentially attract a prison sentence.
Okay.
Okay. So point 4 here, or charge 4 we should call it. No person shall either by writing, drawing or in any other matter alter, deface, mutilate or add anything to any insurance disc for any vehicle, nor shall any person exhibit any vehicle, any insurance disc which has been altered, defaced, mutilated or added to as aforesaid, etc. So they were suggesting that the discs, or the disc on the car at the time, was false.
Yeah.
Okay? Now, later on you'll see in the proceedings of the court, these questions were raised and the guards, they wouldn't produce the evidence.
Right.
So if they were intending on bringing this stuff into evidence under these charges, no evidence was given to the man about false insurance discs. There was no evidence offered to him to prove there was such a thing.
They're expecting to convict this guy without no evidence.
Correct. Okay, the next one is an interesting one. Charge 5 would be obligation to stop. So under the legislation there is a relative obligation for somebody to stop when a guard instructs you. But now this is something we've asked listeners to listen out for, read and research for themselves. There's only a limited amount of times a guard can actually stop traffic on the road or direct traffic on the road, and those are times, first of all, in emergency, and if there's a big event going on where they're directing traffic.
Yeah.
It's not to stop traffic, it's to redirect or direct traffic. But the only technically correct time to stop traffic is in an emergency.
So what ramifications does that have for I don't know, a traffic stop or a checkpoint for tax, for example?
It's not legal.
Yeah, that's the thing.
It's technically not legal unless it's an emergency. Now this is the law itself, and people can read this for themselves. So strictly speaking, you do not have to stop for the guards, and not to say you should continue or anything like that. You should also always check to see if it is an emergency. So the first question to a guard should be, is this an emergency?
So potentially for anybody who's stopped at a checkpoint, whether you do or you don't have tax, which is your own decision, on your car, you have something to get your teeth into there if you're that way inclined.
Yeah, absolutely. The first question to ask of a guard is this an emergency?
Yeah.
Because if it's not an emergency, the stop is illegal. Or if they're not directing traffic, say they're stopping traffic and there is something going on, they should be saying to you, well, we're directing traffic, you need it to go this way or avoid this way, because we want to try and avoid congestion or whatever it might be.
Yeah.
But it's only to direct traffic, or it's only to in an emergency can they stop you.
You see, it's worth pointing out, I think, at this stage, that the remit of the Gardaí isn't to collect revenue on behalf of the state. Now, we all know them for that, but that doesn't mean that's what they're meant to do. So I think there's a huge amount of self-research or homework that can go into all of these points.
Right, so 5 leaves on to 6, and it says here, control of traffic. There is an event attracting large assemblies. So they were charging him with not stopping, although there was no large assembly. So they infer there might be a large assembly.
Yeah. Plus, he did stop.
But there wasn't a large assembly. Plus, he did, which we get into later.
Yeah.
Right. So, they were alleging that he didn't stop, which he did.
Yeah.
Which is proven he did, and which is verified by one of the guards as well. But if you read, it's only in retrospect when you read these charges, you think, how ridiculous can you get? And this is all for the sake of trying to get him on something. Just that's all it was. It was vindictive, malicious, whatever you want to call it. So charge 7 there, pursuant to section 107 of the Road Traffic Act, used to give information on demand by a member of An Garda Síochána. Now,
that's a can of worms, isn't it?
Oh, it's a mighty can of worms. So duty to give information on demand by a member of An Garda Síochána. Now, we've gone through this a few times and we understand the intricacies of this, but in summary it means that, alright, fair enough, the guards can ask you for information, but you are only obliged to give the information if they're saying you've done something wrong, or if they're alleging you've done something wrong. But in this case, what was done wrong? They actually had no preceding charge.
Yeah.
They couldn't actually say, well, you did this wrong or did that wrong, and that's why we're demanding your name. And even then, they can't force you to give a name.
And again, a random traffic stop, there are ramifications there for it in this point as well as the previously mentioned one.
And again, look at the terms. I know it's semantics, but it actually is very important. It says duty to give information. Now, I mean, you or me or Tom, we don't personally work for the guards.
What is your duty to
So
them?
we have no duties to give. And duty is, it infers an obligation, blah, blah, blah. But it's not mandatory. Mandatory is a different thing altogether. It means you have to do something.
Yeah.
Yeah, like you have to do what your wife tells you, don't you?
Oh, of course you do. If
That's
you have
not a
one.
duty.
That's why I don't have one.
Or your husband, whatever it might be. So, you know, if it was mandatory that you have to give information to a guard, it would say it's mandatory to give information to a guard. It wouldn't say you have a duty or you have an obligation. It would say it's mandatory. You don't have a choice. Yeah. Now, if somebody couldn't speak, I'm not sure how they could operate that one either.
Yeah.
So, you know, again, it's a nonsense. All they wanted to do was pile on another charge to frighten Tom and to make him capitulate to something.
Yeah.
So that was that. So the charge, 8th charge here, using and keeping vehicle on which chargeable vehicle duty is unpaid. Okay, so again, that was a nonsense as well. You know, Tom didn't know the situation as to whether or not vehicle duty was paid or not paid, but it's not significant to him because he had borrowed this property.
Yeah.
You cannot control what somebody else does or does not do to their property.
Yeah.
Isn't that fair to say?
Absolutely.
Okay, so, like, I mean, from start to, like, I've read this stuff and you've read this, we've read it time and time again, but to reread it again and again and again, you realise the ridiculousness of what the guards do on a day-to-day basis in order to generate nothing more than revenue for the state. And it's so simple for them, but they do not know, primarily they do not know the law.
Now, all they seem to know or be well versed in is coercion.
Yeah. So in the book, again, there's more detail as to what the charges mean and where you can find the different bits of legislation and so on and so forth. So I think if we jumped on to, where would we go to next now with this?
Well, I think we're going to wrap it up there for today.
Okay.
Because there is I think many people may want to listen to those charges again or listen again in preparation for the next episode. And next week we'll hit you with the next bit.
Can I just add there, Lionel, like, it's fair enough us reading through, and all we're doing really is skimming through and giving a summary of what the book is about to hopefully explain a bit more information to people. But I actually think it's going to be of huge beneficial use, obviously, to listen back to what we've said, but to listen back and have the book in your hand.
Oh, absolutely. It makes a huge difference.
Yeah.
We have it here as we're going through it, and yeah, I think the difference are the amount of information that you'll be able to absorb when you're looking at it as well as listening to the conversation is just astronomical in comparison to just listening. So
And just think, I mean, we don't want people going out there and getting into trouble, obviously, with the different respective relative authorities. But, you know, if you do feel inclined to ask questions, why wouldn't you? You know, why wouldn't you?
well, what do children do when they're first trying to
Work things out.
Yeah, work things out. They ask questions non-stop, and we answer them because why wouldn't you?
You have to.
Yeah. You do.
You have a duty.
Yeah.
And it becomes mandatory, I can tell you that
It
much.
does become
But
mandatory.
they don't stop asking.
No, you've made a very good point there, though, because if you don't know what's going on, and even if you do, you're still entitled to ask questions, because it should be a prerequisite that the person who is demanding something of you knows the answer to your questions.
Absolutely.
Because if they don't, there's something up there.
And in this case, it has to be the law. They have to know the law.
Yeah. Well, how can you enforce something if you don't know what it is?
Well, you can't.
Exactly. We'll pick it up the next day. Thanks a million, Des.
Look, thanks very much.
that wanted
The CLS Talks.